Thank you very much, Vice. We now proceed to give the floor to Togbi Osahi, Alexander Kwamina, Afenyo-Markin.
Lord, may we go to your CV. Lord, you indicate in your CV that you speak, that's biodata point 2 of page 1. The last on that, languages written and spoken. 1, English. 2, Wasa. 3, Fanti. 4, Tree. 5, Sehui. 6, Nzema. So you write Nzema and you speak Nzema, correct?
Mr. Chair, my writing will be a bit of a challenge after some time now, but the speaking, yes, I understand you speaking.
So you would agree with me that that requires some amendment. Would you,
Yes.
with the leave of the chair, re-look at what you've stated there? You know, it's mixed up. So if leave is granted you, share with us which of them you write and which of them you speak.
Thank you, Mr. Chair. I mean, with your leave, I can amend it.
Please proceed with the leave of the chair.
I think I write and speak English. I write and speak Fanti. These are three. I think my writing has also become a bit deficient. So I will say English and Fanti I'm able to write. Wasa more or less is also like Tree or Fanti, depending on the symbols you are using. Yes.
My Lord, if we can go straight, sometimes I get worried when the impression is given that when it gets to me, there's a long delay for nominees. Please pay attention so that we can make progress. I'll plead with you. All right. So tell us which of them you speak, which of them you speak and write.
I speak and write English and Fanti. I speak English, Wasa, Tree, Seshi, and Nzema.
So, just for clarity, you can only write and speak Fanti and English, correct? Very well. Just for emphasis, you said you were your national service. You did it at two places. Go to page 4 of your CV. PDC, Aboso office. So share with us. You know, the PDC was one of the organs of the revolution. It reminds Ghanaians of a certain past. Here we were, a young officer working in that office. A young officer who has now become a human rights advocate. Share with us what you experienced in that office?
Thank you, Mr. Chair. As I indicated to the earlier question, myself and another individual and a graduate, another man who was a graduate from the university, we were sent there as national service persons. And what I used to do, within that, they have what they call an ABICOM, arbitration committee. And so people with some issues may come and make complaints there, and we were asked to write their statements.
So what was the system of adjudication?
Well, it included things like tenancy issues, and at the time, I must admit, to my surprise, when I became a lawyer, it even involved land matters. And the man who had, I think, a degree in land economy, he and one other senior persons were the adjudicators who would try and resolve these matters. And occasionally, they will visit the lands and find out what land boundaries and so on and so forth. So the matters involve little things. Somebody is owing me, somebody has bought my tomatoes, they didn't pay. So people were bringing some of these matters there. Thank you.
Did you consider this as taking away the work of the judiciary? Of course, the revolution only took away the powers of the executive as constitutionally mandated and that of the legislature. But the judiciary was supposed to be left intact. Did you come to a certain conclusion that the PDCs were taking away the very work of the judiciary from what you've just shared with us?
Mr. Chair, at the time, I'm not sure I was that educated to understand that they were taking away the work of the judiciary, because apart from Tawiah, which had a district court and a circuit court at the time, the whole area, there was no court. So from Abosu to Wasankran to Atrebuanda to Insusaiden, there were no courts. So these were ways people were resolving their matters. I rather thought they were helping people to resolve their matters rather than taking it from the judiciary. Thank you.
Lord, with respect, may we go to the Constitution, Article 128. The Lord may read Article 128(4).
Thank you, Mr. Chair. Article 128(1) or 4. A person shall not be qualified for appointment as a justice of the Supreme Court unless he is of high moral character and proven integrity and is of not less than 15 years standing as a lawyer.
My Lord, with respect, from what you have just read, how many essential qualities are required for such nomination?
High moral character, proven integrity, and at least 15 years standing as a lawyer.
Lord, with respect, on each of them, demonstrate that proof to me.
Thank you, Mr. Chair. On question of moral character, I think that I have demonstrated that through my life. I practiced law in Ontario for years before my elevation to the Supreme Court, to the High Court. A check was done there was no ever complaint at the Law Society against me. I've proven my integrity on the bench by doing my work. As I said, I have desired to always be unashamedly ethical. And come October, I'll be 29 years as a lawyer. So that is what I would say on this one. Thank you.
Chairman, your indulgence, I wish to raise a matter that strikes at the heart of our constitutional commitment to justice and fairness, the presumption of innocence. My Lord nominee, we have observed an increasing pattern in which state prosecutors, including the Attorney General, convene press conferences or make public statements that cast serious aspersions on the guilt of accused persons, often long before a court of competent jurisdiction has had the opportunity to hear and determine the matter. This trend appears to risk eroding constitutional guarantees under Article 19(2)(c) that every person is presumed innocent until proven guilty. Indeed, the European Union has taken significant steps in this area, particularly through Directive EU 2016/343, which restricts the public dissemination of information regarding criminal proceedings to protect the fairness of trials and the dignity of the accused. Ghana, by contrast, appears to be drifting towards a culture of trial by press and public opinion. And this was long observed by my Lord Ackaah-Boafo in the Tagore case. My Lord nominee, what I'm going to ask you seek to explore your views on how to reconcile prosecutorial communication with the Constitution's promise of due process, judicial fairness, and respect for the rule of law. I will basically, like I've stated supra, rely on the constitutional provision of Article 19(2)(c), and we'll look at principles of fair trial due process, ethical prosecutorial conduct, and comparative standards from the European Union and other democratic systems. Now, how do you interpret the constitutional guarantee of the presumption of innocence under Article 19(2)(c) in the context of public commentary by prosecutorial authorities on cases yet to be sent to court or before the courts?
Thank you, Mr. Chair. On matters before the court, I think that as lawyers, each one of us ought to be aware of Rule 38 of the Legal Profession Act, which speaks to the fact that matters which are before the court, if you are counsel, you don't comment on them. So that will be my response, that any lawyer who leaves the courtroom and meets the press outside and begin to talk about what is happening in the courtroom clearly is breaching that rule. On the issue of providing information, I think that this is where there's a thin line. The thin line is that this society has grown a bit sophisticated and want to receive information. I think I've asked questions this morning about people on social media doing disinformation and misinformation. So that if the Attorney General takes the position that these are matters that I ought to place before the public to be aware of, it may be within the context of providing information. But if the Attorney General goes ahead to make comments alluding that the person is already guilty, in my view, that will be a breach of the Constitution. But providing information to the public who want to know that this is what we are investigating. I think receiving information from the right source is always better than getting it from the social media, which sometimes clearly are manipulated. Thank you.
Chairman, just bear with me, Chairman, bear with me. You see, I would prefer if leader wants to ask his own set of questions, under normal circumstances, I'm the last to ask, then you come in. If he wants to be the last after me, I don't mind. But this issue of follow-up, he should reserve all of his points. When I'm done, he can come in. I will plead with you, Chairman.
Thank you very much. We are Parliament governed by rules. So when a question is asked, the rules allow a follow-up question. So following the same practice within the rules, I will proceed to give the floor to the majority leader.
You quote the particular rule for our record. Which rule? You quote the rule.
A follow-up.
Chairman, please quote the particular rule.
So I will look for it.
Yes, you look for it. Let's patiently look for the rule, rely on to make a determination, and let it go in the records. Quote the rule that allows somebody else to interject with a so-called follow-up when the person is entitled to his own. It's entitled to his own set of questions. So quote it.
The public, let's look at Standing Order 89. It's on supplementary question. And if I may read the relevant portion, 89.2 or 89.3. Any other member may be allowed to ask not more than 2 supplementary questions, except that the majority and the minority or co-leaders may ask not more than 5 supplementary questions on the substantive issue. It is on this order that I am standing to give the opportunity to the majority leader to ask a supplementary question.
Chairman, with respect. Chairman, with respect. You may continue to exercise your powers, but let me help you. The rule you've just quoted governs plenary proceedings. If you want to apply it mutatis mutandis, you are supposed to still be guided. Because I am asking the question, that rule says, after the person asking the substantive question is done, I must be done with all my follow-ups. Before, then you would ask me, are you done? Before going on, I laid bare each of the steps I want to take. So you should ask me first, am I done with that substantive question? If indeed I say yes, and you want to apply the plenary rule, mutatis mutandis here, you may now give him the chance, but don't say you are guided by the rules, and even when I am not done with my supplementary questions or follow-ups, you want to give him the chance. Let's stop this. The leader is entitled to come in anytime when we are all done. He can ask his own questions, so stop this. It will help.
Honourable members, it's not everything that I place on record. You realize that before giving the opportunity to the majority leader, I asked the questioner that majority leader will want to ask a supplementary question, not into the microphone. So if you are not done with a supplementary question, you can also tell me that you are not done with a supplementary question on that particular question. That doesn't mean I do not have a floor or do not have the ground within the rules to ask the leader to ask a supplementary question. So if you feel that you have a supplementary question on the question that you have asked, you can ask that particular question, and thereafter, I will give the opportunity to the majority leader to also ask a follow-up question. But rather, you said, which rule am I relying on? I have shown you the rules. So I'm not operating outside the rules.
There are rules that govern committee work. Chairman, anyway, I'm not done, so let me finish my supplementary. Now, let's deal with the issue of ethical guidelines. You have just spoken about the boundaries, that it could be in the public interest for the minister to put out some information. Now, do you think that there is a need to provide some ethical guidelines to govern this prosecutorial communication?
Thank you, Mr. Chair. And if I may seek clarity, ethical guidelines as to guidelines governing how ministers do their work, or with this particular situation?
Very well. So, in my first answer to you, first question to you, you answered in a twofold. First, you said that if the Attorney General is saying anything that would prejudice the outcome of the case, then that would amount to a breach. Then you again said that it could as well be that there's a need to provide information to the public regarding the case in this era of social media and all. So on the basis of what you've told us, I am mounting the follow-up to ask whether on such a thin line you hold the view that there's a need for some legal or ethical boundaries that should govern public statements by the Attorney General or prosecutors about the accused persons before trial commences.
Thank you, Mr. Chair. I think that the Attorney General remains a lawyer. If there is any member of the Attorney General's office who is a lawyer, I would say that they still must advert their mind to LI 2423 as lawyers, and their roles as prosecutors are well set out in the LI. If the person is not a lawyer and will not come under that ambit, then maybe what you are asking may be appropriate. But I think your question clearly, hardly do we see police prosecutors, for example, doing that. So that if it is someone who already comes under LI 2423, then my thinking is that there's already some rules there governing how such work ought to be done. And in regards to public statements, that is covered under Rule 38. Thank you very much.
Now, to what extent do such public declarations of guilt by state prosecutors, even before trial, in your view, can undermine public confidence in judicial independence and the impartiality of criminal proceedings? My Lord, I would give you a bit of a background just to help the situation. My Lord, sometimes, the court is often accused of not ensuring justice, not being fair, all because a certain impression has been given them that somebody is already guilty. Why did the court even grant bail? Why is the court saying that he's acquitted and discharged? Why is the court using rules of procedure to free somebody? So, with this as a background information, would you say that to some extent, some of these public declarations, which in the ordinary man's language, understanding, amount to a guilt, will undermine the public confidence in the judiciary, because it's already been said out there, and you are now sitting in as a court of justice to determine the matter?
Mr. Chair, when it comes to judicial independence, clearly, as we understand it, there's decisional independence and institutional independence. The decisional independence is the judge's ability to hear evidence, the facts, and applying the law. So that I think I would rather be shocked that any judge who understands his role ought to be influenced by a statement made by a prosecutor or the Attorney General even before the matter comes in. I would do my work, or judges do their work, based on the evidence they receive in the courtroom. Yes, for an uneducated mind, it might create the impression that the judge has done something untoward. But we only speak through our judgment. As a judge, when I write a judgment, I must have my spirit in it. So that when I have demonstrated that and you disagree, my position is read the judgment. And your opinion, you may want to disagree with me, but I have spoken. So yes, if providing that information will make people think that the person is already guilty, but the trial did not meet that standard, I think it rather undermines the integrity of the person who put that information out there than the judge. Thank you.
My Lord, I know definitely Apau, as he then was, and his brother Pesera, the position they took in the very matter that our respected AG did in the Tagore case. It provides a new pathway, which you've emphasized this morning. But essentially, reading that judgment, I got the impression that you, the judges, are often concerned, or perhaps you are put under some pressure when the public perception is already out. Because if you see the way my lords emphasize the point that the fact that a case gains public notoriety does not whittle down the essential ingredients required to prove the guilt, it tells you one thing. It's on this basis that I want to ask you whether unmeasured approach in such public pronouncement by the prosecutor, in your view, undermines the very justice of the matter. In all fairness, you are on oath.
In all fairness, yes, let me say that, especially as a teacher of advocacy and legal ethics, I think I will be concerned when lawyers leave courtroom and make comments on matters pending, and sometimes the fact will not represent what took place there. I'll be concerned about that. But prior to filing the matter, if it is something providing information, I would think that might be appropriate, but there is a certain line. Do not make comments basically throwing somebody under the bus before even a suit is filed. Thank you.
Lord, then human rights, remedies.
Before you go to human rights remedies, I will proceed to give the floor to the majority leader to ask a question.
No, wait, Chairman. On the presumption that you've not, please. Chairman, you know, in my opener, I can share with you, this is the main question, under 19.2c. The remedies comes under, they are all follow-ups. So I only give the subtitle to help the nominee. So when I under the same thing, please, they are all my follow-ups. I have main question, I've drafted them carefully. So let me get done. He would have the opportunity, please. It's my follow-up. I'm the questioner. The rule allows me to ask 5 supplementary. So let me finish. They are not, they are 2. Chairman, they are here. I've listed. I'm going by my own work.
So to go by the rules that I have quoted, you are entitled to 5 supplementary questions, and the questions that you have asked following the substantive questions are more than 5. A question was asked whether or not he is a member entitled to ask a question. We should make reference to Standing Order 2177, which entitles him to participate in the decision. So you have the floor. You can ask a supplementary question.
Thank you very much, Chairman. I don't know when my minority leader started fearing me asking questions. That's the only sense I get, that, you know, you're so scared of me asking a question. My Lord, congratulations on your nomination. Will a prosecutor institute prosecutions if he doesn't presume you're guilty?
Thank you, Mr. Chair. Certainly, a prosecutor will believe in his or her case before they file it. and it doesn't always work the way it is. So yes, a prosecutor is entitled to have an opinion of his or her case. As to whether or not it will meet the threshold is another matter. Thank you.
So your answer is yes, a prosecutor will presume you guilty before he files his case.
That is correct.
So the presumption of innocence, is that an obligation of the court or an obligation of the prosecutor?
I think the presumption of innocence is more to do with the court than the prosecutor, because ultimately, when you are starting with the prosecution, I, sitting in that chair, must take the position that you are presumed innocent until I hear the evidence. If the prosecutor's mind is you are guilty, that is his prerogative, but that should not influence my decision. Thank you.
And for clarity, did I hear you say that before a prosecutor institutes the action, at the time of investigations and conclusion of investigations and the gathering of facts based on which the prosecutor believes that there's a basis for prosecution, if that prosecutor goes public with the details of the facts gathered that found his decision to institute prosecution and then announces his decision to institute prosecution, to the extent that he hasn't come to your court yet, you think that that level of sharing of information is okay?
That is my view, that provided that information, you've conducted, the prosecutor has conducted his or her investigation. He says that is what I have. I'm going to court. And he makes that, provide that information. It is fair game for the prosecutor. As to how, whether or not he will succeed in court is another matter. So yes, if the prosecutor provide that information, I think my only caveat is the prosecutor creating the impression in the mind of the court, in the mind of the public, that this is a done deal. That clearly will have a problem. I will have a problem with that, because that is when the minority leader's question then kicks in. Because in the mind of the public, the person is already guilty. So that when the court returns a decision, that is where the bashing of the court may come in. So I think it is a very nuanced way, or there ought to be a nuanced way of doing it. Provide information to the court, but as much as is possible, I think prejudicial comments ought not to be made. Thank you.
So, Honorable Majority Leader, be reminded that you are to ask 5 supplementary questions. Yes, so you have 2 more.
In North America, where you have practiced, when prosecutions are ongoing, do the media and lawyers comment on the proceedings, or that in some states, even the proceedings are covered live on television? Does that happen or not?
I call it the Johnny Cochran syndrome. It's more in the United States than in Canada. Matters in Canada, you don't comment on it. We stick to the rules, and you only have lawyers speaking to it after judge decisions are made. The Johnny Cochran syndrome is more to do with the Americans than the Canadians. Thank you.
My last question. The system of appeals that we have, from the High Court to the Court of Appeal, and ultimately, potentially to the Supreme Court, and even a review, the system of appeals, does that provide the accused person remedy against any potential pressure that may inform a judge giving an erroneous ruling or not?
Certainly, yes. I mean, if somebody is not satisfied with a decision by the High Court, you can go to the Court of Appeal, and from the Constitution, they actually have a right of appeal. So yes. And in recent times, we've seen the Court of Appeal reversing some High Court decisions. So yes, it's a remedy. But the bottom line is, if there is a way to avoid this, can we find a better way of doing it? That would be my suggestion. Thank you.
Yeah, the floor is back to the ranking member. You have the floor.
Now, may I know from you, Honorable Nominee, whether, in your view, there are available remedies for accused persons who are publicly labeled guilty by prosecutorial authorities before a fair trial takes place. In other words, suspects who before even sent to court are publicly labeled guilty. If there are some remedies for them, in your view, my lord?
I find it difficult to look out for remedies because, for example, in recent times, we've heard of lawsuits where somebody will go to court that injunct a public institution or somebody from investigating me. I do not think such lawsuits are appropriate. Ultimately, when you are being investigated and the prosecution says, I'm taking you to court, I would rather think that the individual may want to gather his or her information, and if at the end of the prosecution the person walks away free, then that may be the appropriate time to mount an action. Thank you.
Now, flowing from that, do you think that the judiciary must, and here proactively, intervene to restrain state actors whose conduct or statements are seen to be undermining the presumption of innocence rule?
I know as a fact, myself and other colleagues involved in matters would warn lawyers, counsel involved in the matter, not to make prejudicial comments when the matter is ongoing. But if the scenario as painted during the investigation stage, the prosecutor is providing information in the public, I do not see how the kind of jurisdiction that the judiciary may have to issue some injunctive orders or some orders against such a person. If they haven't come to us, we do not have jurisdiction to deal with such matters.
Given the opportunity, or when the opportunity avails itself, are you likely to come out with some judge-made laws to guide this process? In the light of your position in a recent matter, I read your judgment. You made a profound statement. I would, very well, you answer it, I'll go, that's my next thing. Do you think that there's a need for you to come out with some judge-made guidelines for this whole matter, given the opportunity?
Thank you, Mr. Chair. I think decisions of judges or judges make decisions based on facts, analyzing the facts, and applying the law. So that if the fact certainly is to that effect, that a judgment could be written to make such or provide such guidelines, I think that would be fine to do. So the simple answer to your question is yes, if the facts will support that. But I'm not sure I can sit here and say that based on the narration you've given me, I am going out there to write a judgment to gag an investigator. Thank you.
Now, some comparative analysis here. You know, the recent EU position, this recital 18 of the EU directive that I relied on, that limits the disclosure in the public interest or to assist investigations. Do you think that as a country, a growing democracy, we are almost 30 years plus, this principle should be seriously observed against this rising trend of political and prosecutorial commentary on matters of criminal jurisprudence?
Mr. Chair, I think as a democracy, we are building, and we are learning. Mr. Member will recognize that until just from 2018, even full disclosure to an accused never existed. Now we have it. So I think that what you are asking for, I think that we may get there, depending on how, us as a society, you as lawmakers see that. I think it's a conversation that can be had. But we need to understand that some of these situations come about as we learn and we want to educate ourselves. Thank you.
Lord, your senior brother, Afenyo-Markin, JSC, as he then was, in the matter of Jesse, Emis Texan, and 2 others, versus the Attorney General, in suit number J1/10/2015, held in his dissenting opinion as follows, quote, "Before I rest, I wish to make it clear that in our constitutional dispensation, care must be taken not to create a statutory institution without checks by the court on how they deal with the citizenry. Failure to hold them in check will be a throwback to the era of unlimited executive powers, which will certainly undermine our democratic dispensation," end quote. What are your own views on this matter as you rise to the highest court?
I think I see this as anchoring in the doctrine of separation of powers and the court having the duty to interpret law and be more or less as a watchdog or a guard against excesses. Of course, the court ought to recognize its duties and its functions. So that statement is profound based on the facts of the case as dealt with by Afenyo-Markin JSC. Many times, some of these cases come up, and I think if the occasion arises to re-echo such words, or as part of our education, that will be done. Thank you.
What about looking at it in the context of human rights? Looking at this statement in the context of human rights, have you any views on?
Well, I think with the greatest respect, we sometimes bandy things around as human rights, such that anybody at all sometimes will raise certain issues to say that it is my right. But we must always look at Article 41, I think it's in the K or J, which talks about the rights and the responsibilities. If the Attorney General or the prosecutor has a role to play, and he says, I've investigated the matter and I'm providing information to the public, I think, as I've already said, that may be within the mandate. But anything else that may go on to prejudice the trial, certainly if the occasion arises, can be dealt with. Thank you.
But you've already indicated there's a thin line, correct? Yes. Very well. My Lord, let's deal with some food you have already served the judiciary. You've cooked something. In your concurring opinion in the matter of Ackaah-Boafo, alias Raga Jiwa versus the Republic, decided on 27 March 2025, as well as broader constitutional and legal frameworks governing arrest, investigations, due process, and personal liberties in Ghana, there are some few things that I would want to bring to your attention for your views on. I must say that these would further be anchored on Articles 14, 23, our Criminal and Other Offences Act, and of course, ethical standards for law enforcement. Now, at page 20, paragraph 25 to 26, these were the very veritable words you used, and I quote, "My lords, another aspect of this appeal on which I wish to express my opinion concerns the reason for the appellant arrest in the first place. In my view, this case, like a few others I have had the opportunity to review, presents and reveals a troubling trend in the manner in which investigations are conducted by the police and prosecutions are carried out in our courts. In this case, I question why the appellant was arrested, as the record of appeal reveals that, apart from the statement of persons arrested alongside the appellant, who indicated that he was part of the robbery, no independent evidence linking the appellant to the robbery was obtained by the police." You further went on at paragraph 26, and these were your words. Quote, "My lords, in my respectful opinion, the time has come to be blunt with investigators. Arresting an individual solely based on another person's statement without a thorough independent investigation poses significant risks. Apart from the obvious ethical lapses inherent in a laissez-faire attitude towards investigating accusations, the accuser may have personal motives such as revenge, bias, misidentification, or even deliberate deception or deflection of attention from actual perpetrators, leading to wrongful arrests. Moreover, such practices encourage arbitrary policing, fostering abuse of power, and the erosion of public trust in law enforcement. They also create opportunities for individuals to manipulate the system for personal gain, using arrests to settle scores, eliminate rivals, or shield actual perpetrators. It is imperative that investigators recognize the necessity of conducting proper investigations, supported by corroborating evidence such as forensic proof, surveillance footage, and credible eyewitness testimony to mitigate these risks and uphold justice," unquote. My Lord, from what you stated in your concurring opinion, you criticize the police for making arrests without independent investigation. What, in your view, are the constitutional obligations of investigators before depriving a person of their liberty under Article 14, respectfully?
Thank you, Mr. Chair. I think my view is rightly captured in the dictum you read out. I am of the view that, and as I indicated in that case, the record reveals that apart from those who were arrested with him saying that he was part of us, there wasn't any investigation that was conducted to link the individual. And these statements were actually even not repeated in court, apart from caution statements. So that is where the statement comes from. My view is that there is a need to have proper investigations and not a co-arrestee say so be the basis for prosecution. Thank you.
Lord, flowing from this, you, like, as you've already indicated, you've won against arresting individuals solely based on statements from co-accused persons. How then should the judiciary guard against arbitrary arrests that are used to settle personal scores or suppress rivals? How should the judiciary boldly confront this to guide our democracy and the rule of law?
Thank you, Mr. Chair. I think it depends on what stage we are at. If an investigator comes to court and said, "I've done this investigation, I arrest somebody and put a person before the court," I think at that stage it will be difficult for a court of law to say that at that preliminary stage there's no basis, let him go. The only way the judiciary can confront this is when presented with the compendium of evidence, assess it, and say that there wasn't no basis for this arrest and no basis for the prosecution. So, and I think we've done so far. We've done well so far when it comes to such things. If ultimately there's no evidence, there's no evidence. And the court makes a decision. Thank you.
Lord, now you are going to the policy court, where you will want to propose reforms. So let me ask you, it's a court of liberty. Nobody would be up to be checkmating unduly, except perhaps, of course, the matter comes up for review, or long after you've left, a new panel comes up with a new view, which is the case in our courts. But for the time being, you've described this laissez-faire attitude in policing as a threat to public trust, and I agree with you. What, therefore, in your view, should be the legal or institutional reforms necessary to ensure investigations are thorough, ethical, impartial, and conclude in good time?
Thank you very much, Mr. Chair. I think I would take a cue from my last answer. If until matters are filed in court, based on our rules, based on the laws in the country, I think the court will have very limited role to play until matters are filed. So that these guidelines ought to come from the Ministry of Attorney General and the prosecutorial services to guide this. But we know we also have matters of delay in our rules. In other jurisdictions, they apply so well, where no matter the charge, it could be stayed if the matter has been unduly delayed. So these are things that we can have conversation about. Should somebody stand trial for 5 years without calling any evidence? These are conversations that we can have, but I'm not sure at the investigative stage the court will have much to do until matters are filed. Thank you.
My Lord, the police prosecutor comes to your court, says that a big man, a businessman, has reported of stealing. The stealing was a check that, of course, he signed a blank check. And the house